Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Approaching the podium with me. Your Honor, in this case, subject to the court's approval, Ms. Meadows will enter a plea of guilty, Your Honor, excuse me. She'll enter a plea of guilty to the charged offense in this indictment of one count. The punishment on that, Your Honor, will be 2 years of probation pursuant to judicial diversion. She will be required to complete anger management and parenting classes as a condition of probation. She'll be responsible for the court costs. She has signed a plea sheet to this effect, Your Honor, and there are pretrial jail credits on here, and there is a certification of her diversion eligibility as well.
All right. Ms. Meadows, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record.
Mackenzie Brooke Meadows.
Ms. Meadows, you are here today charged with a single count of an indictment of child abuse or neglect. Have you seen or been shown a copy of those charges? Talked them over with Mr. Talbot. You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter this plea of guilty. Do you understand that you can plead not guilty and have a speedy and public trial by jury in this court?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by using a subpoena.
Sir.
You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. Now, I'm going to ask you to speak up a little bit. The lady in front of me is taking down everything that's being said, and she's recording it. So it's important we get a verbal response. You understand that if you went to trial, I'm sorry, I may be repeating myself, but if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal. Do you understand that?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyer's worked out?
Yes, sir.
You understand we're going to talk about this. You're entering this plea under a specific statute for first offenders, people who have never been convicted or in trouble before. What that means is that you're going to be placed on probation for 2 years. If you successfully complete that probation, don't violate any of the terms and do everything that's required of you, then you can apply to have your record expunged at the end of that 2-year period. That means to wipe this off your record as though it never occurred. By contrast, if you violate the terms of your record, of your probation, this will become a permanent conviction on your record and will be there in the future to make more severe the punishments you'll receive if you're ever again convicted of a crime. Do you understand that?
Yes, sir.
Do you understand everything I've explained to you thus far?
Yes, sir.
Do you want to plead guilty and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand that if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you have been lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
Yes, sir.
You understand I can't accept your plea unless I'm satisfied you are in fact guilty and there are facts to support it. General, are you going to supply the facts for me, or?
Judge, I can supply the facts.
All right, I want you to listen then, Ms. Meadows, as the state tells me what their evidence would be at trial. Please go ahead.
Judge, law enforcement received a report in August of 2023 of an 11-month-old infant that had bruising about her body that was not consistent with normal child play or accidents. Through their investigation, they determined that the baby was in the care of the defendant at an in-home daycare that she cared for alongside her other children. And those are the basis for these charges that did occur in Dixon County. Judge, I would also like to let the court know that the victim's mother is present in the courtroom and has provided a victim impact statement for me to read on behalf of the family.
All right. Then I'm not asking that you necessarily agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to enter this plea according to this agreement?
Yes,
Are you satisfied with your attorney's services?
yes,
You feel like Mr. Talbot has done a good job of representing you competently?
yes.
Mr. Talbot, do you know of any reason she should not enter this plea?
No, sir.
Then I will ask you to step back and have a seat so I can hear from the victim's impact statement.
Sit and watch.
General?
My name is Alicia Crouch. I am the mother of Blakely Crouch, who was harmed before her first birthday, a time when she was too young to speak for herself or to defend her little body. No infant should ever have to endure harm, especially from someone entrusted with their care. The impact this crime has had on me as a mother is something I carry every single day. My trust, my peace, and my sense of security were ripped away. Emotionally, I live in constant fear that this could happen again, whether it be starting a new daycare, preschool, or kindergarten. That fear is something I will carry for a long time. At the time of the crime, it was especially hard for Blakely. She struggled with eating, taking bottles, and being away from people who made her feel safe. The aftermath was overwhelming. I had to take time off work to ensure she was cared for and to find a safe place for her. We attended follow-up appointments with her doctor and with child services. Even once I found a safe daycare, the challenges continued. Blakely did not trust the staff. She screamed for weeks before she was finally able to adjust. Blakely just turned 3. She is a smart, beautiful, energetic, funny, and loving toddler with a bubbly personality. I pray that she grows up with no memory of what was done to her, but as her mother, I will never forget the harm that was caused to my sweet Blake. Despite everything, I hope the defendant uses the resources provided by this court to reflect, learn, and do better. What was done cannot be undone, but what one chooses to do moving forward is within their control. My hope is for accountability, integrity, growth, and genuine change. The crime has left a permanent scar on my family. Thank you for giving me a chance to speak for myself and for Blakely today.
General, it's my understanding then that the victim, the mother of the victim in this case is in agreement with this disposition?
Yes, Judge, we met with her and with support persons to explain the process, going through everything, and we reached this settlement agreement together.
All right. Mr. Talbot, you and your client come back to the podium, please. Ms. Meadows, you've heard the very articulate and intelligent victim's statement that was a powerful statement that was given by the victim's mother in this case. You still wish to enter this plea?
Sir.
You've heard her basically state that she hopes that you utilize this as an opportunity for you to reflect and to try to improve your situation and to make sure that nothing like this ever happens again. You understand that?
Yes, sir.
You understand that if you violate the terms of this probation, then you will not only have a conviction, but you will serve 2 years in prison as a result of this. You understand all of that? All right, then Mackenzie Meadows in docket number 2024 CR 230, upon your plea under 4035-313 to the offense of child abuse or neglect or endangerment, order that you be placed on probation for a period of 2 years. And the conditions of that probation are that you must complete an anger management and the parenting classes. You must pay the court costs. As a judgment of the court, you'll need to see the probation department.
Thank you, Your Honor.